Welcome, everyone. I'm Steve Pollak. I'm the president of the Historical Society of the D.C. Circuit. We have an exciting program for you. Madness or Badness, Duran and the Evolution of the Insanity Defense in the D.C. Circuit. Let me refresh you as to what the Duran case was about. On October 29, 1994, a man in a long, floppy raincoat standing by the White House fence along Pennsylvania Avenue took an automatic weapon from under his coat and began firing into the White House grounds. 29 rounds, where a group of men and women were standing, one of whom appeared to be President Bill Clinton. An onlooker with a video camera turned it on hearing the gun reports and recorded the events you see unfolding. This tape was played at the trial. So let's turn to our program today. Stephen J. Morse, Ferdinand Wakeman Hubbell Professor of Law and Professor of Psychology and Psychiatry and Law at the University of Pennsylvania, a recognized expert in all matters relating to the insanity defense, will set the stage for our program. Following Professor Morse, the attorneys who tried the Duran case in 1995 will reenact their closing arguments on the insanity defense issues. A.J. Kramer for the defense and Eric Dubelier for the prosecution. Trial Judge Charles Richey will preside, played by his law clerk at the time, Kimberly Brown, Associate Professor of Law at the University of Baltimore School of Law. So, Professor Morse, take over.
Good afternoon, everyone. It's a pleasure to be here. My remit is basically to go through the history of the insanity defense for you, making a couple of, I hope, pithy remarks about its virtues and defects, with a special attention to the insanity defense in the D.C. Circuit and after the Insanity Defense Reform Act of 1984. Well, pre-Hinckley, first, what is the insanity defense? And what I'd like to argue to you is the insanity defense basically gives legal life to a basic moral intuition that I think most of us share, which is that there are classes of agents who, even if they do wrong, are not morally responsible agents and do not deserve blame and punishment. Think of a 10-year-old who commits a homicide intentionally, knows he's killing intentionally. You wouldn't think that person is fully responsible, or perhaps, depending on how soft you are, responsible at all. Think of people who may have dementias and act assaultively. You wouldn't dream of blaming and punishing them. And at least some people with major mental disorder who are so out of touch with reality when they do what they do, you would also think these are people who do not deserve blame and punishment. It's not just about social safety. It's about deciding who can we fairly blame in a decent society and who can we fairly punish in a decent society. Now, as I know most of you are lawyers in the room, the way we give legal life to that notion is we have basically a two-part test everywhere. First, the defendant's got to suffer from a mental disorder. For the insanity defense, that is a legal concept. What we in the law consider a mental disorder for our purposes is not what the docs might prefer in the clinic, consulting room, or hospital. We get to call the shots in the courtroom. And then, just being mentally disordered, even if it plays a causal role, is not enough. You have to have some other kind of effect of the mental disorder on you as an acting human being that suggests you're not responsible for yourself. And the dominant view, as you all know, is the McNaughton test from 1843, in which the House of Lords announced that if by reason of mental disease you either didn't know the nature and quality of your act or you didn't know that it was wrong, then you would be excused. And you can see that's a cognitive test. How can we blame people who don't know what they're doing? Or how can we blame people if they don't know it's wrong? And the reason they lack that knowledge is not because they're careless or not paying attention. It's because they have some obviously disordered process. We may not understand the process, but there is something obviously disordered about them. Now, the interesting thing about tests like that is they're not self-defining. We could define them broadly or define them narrowly. Take Andrea Yates. Narrowly, she knew she was killing children. She knew drowning them in a bathtub would in fact kill them. She certainly did it intentionally. But why did she do it? She did it because she wanted to save them from Satan's eternal torments. And you sort of, did she know the law? Yeah, she knew it was against the law of Texas. Did she know her neighbors would probably disapprove? Sure. But if she really believed that if I don't kill my kids now, they're going to be tortured eternally, which is a very long time, you can imagine why she might say, I should kill them now. So if you look at her broadly, she didn't know what she was doing. Narrowly, she did. Then, in a minority of jurisdictions, there is also what's called an irresistible impulse test. That is, so even if you know what you're doing and know that it's wrong, you somehow can't help yourself. After Hinckley, they came in for heavy water, as I'll tell you in a few minutes. Now, from 1929, the D.C. Circuit had both. Starting in the 1880s, you had a McNaughton-style test, and in 29, an irresistible impulse test. Famously, in 1954, Judge Bazelon, in the Duran decision, decided neither test, neither irresistible impulse nor McNaughton, was an adequate test. And instead, he came up with a quote-unquote product test. An accused is not criminally responsible if his unlawful act was the product of mental disease or mental defect. Basically, he thought this gives the mental health professionals a real good chance to come in and explain how mental disorder has affected this defendant's criminal behavior. And that was supposed to make the insanity defense more rational and more orderly. In 1962, as many of you probably know, the Model Penal Code was promulgated. Basically, it had both a cognitive prong and a cannot control himself prong, and instead of putting things in terms of all or none, it's lacked substantial capacity. And this looked like a broader, more forgiving, more scientific test. That's a mistake, by the way. An insanity defense test is not a scientific test. It's a legal test. We may want scientific or clinical knowledge to help adjudicate it, but ultimately it's a legal test. In any case, by 1982, the day of the Hinckley trial, it had become the majority rule, including adoption by all but one federal circuit. And in 1972, in the D.C. Circuit, in Brawner, the court here rejected Durham, finding it unworkable, which it was, and I won't go into why it was unworkable. It was a failed experiment, noble but failed, and adopting the Model Penal Code, also permitting, interestingly enough, permitting a defendant to use evidence of mental disorder to negate the mens rea part of the prima facie case. Now, here are the supposed virtues of the Model Penal Code. It's not all or none. It uses appreciate, a broader term than know. It includes a control test, which was supposedly a virtue, and it permits broader, more helpful expert testimony. None of those supposed virtues was a real virtue, because, in fact, the evidence suggests that it doesn't matter what test the jury or judge gets, it doesn't affect the outcome. Interestingly enough, narrow the test, broaden the test, it doesn't affect the outcome. And moreover, even under the allegedly narrower test, experts got to say anything they wanted. And there was no narrowing because the test was narrower. Hinckley itself, the interesting thing about Hinckley was it was tried in federal court. It could have been tried in local court too. Different burden of persuasion on legal insanity. Burden of persuasion in federal court where it was tried was, once the production burden was met, the prosecution had to prove sanity beyond a reasonable doubt. If it had been tried in the local court, Hinckley had the burden to prove he was legally insane by a preponderance. I have never seen, and for my sins, I have read the transcript. I have never seen a case I thought, by the way, beautifully tried on both sides, wonderful experts. I never saw a case I thought was more evenly divided in terms of the evidence, 50-50. 50-50, whatever you believe. If the prosecution has to prove he's sane beyond a reasonable doubt, the prosecution loses. So procedurally, it was the right result. In the local court, Hinckley might have lost. just on the burden of persuasion. And that's an important story, and we'll come back to it. As you all know, there was a national firestorm of revulsion at the verdict, at the insanity defense, and especially at control tests. People thought he had been acquitted under the control test. There was no evidence for it, but there was revulsion. What does this test mean, and how can we apply it? Reagan Justice Department recommended abolition of legal insanity. The American Psychiatric and the American Bar Association wanted to retain the test, but said, get rid of control tests. The reason? We don't know what they mean. We can't operationalize them. We can't give any kind of adequate expert testimony. I would like to say that's what they said in 1982 and 83. They were right then, and they're still right. I'll come back to that. The American Medical Association recommended abolition, but they came up with an argument that was so preposterously bad that it didn't pass the smell test. There was also enormous legislative ferment. The large majority of states that had adopted the MPC rule, this is after Hinckley, legislatively or judicially abolished it. In addition to narrowing the test, many states have now shifted the burden of persuasion on legal insanity to the defendant, either by preponderance or clear and convincing evidence. McNaughton and its variants have once again become the predominant majority rule. 5 states abolished the insanity defense entirely. The only way mental disorder comes in is if you use it to negate mens rea of the prima facie case. 4 state Supreme Courts upheld constitutionality. A 5th, Nevada, found it unconstitutional. That case is someday going to percolate its way to the United States Supreme Court, which has never decided whether the insanity defense is constitutionally required as a matter of substantive due process. In Clark against Arizona in 2006, the court approved Arizona's most narrow ever, anywhere in the country, insanity defense rule, which was just the no right from wrong prong of McNaughton. But Clark also held that Arizona's rule excluding all mens rea negating evidence was constitutional. That's a very tough rule. Well, in light of all the criticism of abolition, the Reagan Justice Department decided no longer to oppose retention, and Congress passed the Insanity Defense Reform Act of 1984, which is the first comprehensive federal legislation concerning legal insanity and related issues. It took effect in October of '84 and applies uniformly in all federal criminal trials, of course, including those in the D.C. Circuit. It is codified as 18 U.S.C. 17. I'll just basically go through what's different about it. First, it seems to modify the standard for insanity previously applied in federal courts. It required a severe mental disorder. It meant to include lesser mental disorders like personality disorders or the like. It used appreciate, the allegedly broader term. But as I've told you, there's no good study of what's happened in the federal courts, but there's no evidence from what studies there are that the test makes a difference. It moved the burden of persuasion to the defendant by clear and convincing evidence. Now again, there's no evidence from federal courts, but there's clear evidence from cross-sectional studies that changing the burden of persuasion, shifting it to the defendant, is the only outcome determinative change that has occurred in the wake of Hinckley. That is what made a difference. It's really hard now for defendants to win if they got the burden of persuasion. It also prevented defendants from giving expert testimony on the ultimate legal issue. In other words, a psychiatrist or psychologist in an insanity defense case now in federal trials cannot at the end of his or her testimony say, as a matter of my reasonable medical or psychiatric or psychological certainty, I think the defendant is legally insane. Cannot do it. That's a jury question. It's not an expert question. When experts opine on that issue, they're taking off their white coats and they're stepping into the jury box and they're just a 13th juror. It's a totally legal conclusion. Now, it eliminated the defense, not that there was a defense, of diminished capacity, but lower federal courts have held that defendants can introduce evidence of mental disorder to negate mens rea with some particular limitations that are technical and I need not go into. Okay. Future of legal insanity. The real question to me is how it will wax and wane as political events occur. You get a deeply unpopular verdict, it's a national spectacle, the Hinckley trial, revulsion. One could imagine, let's say in the wake of the first trial of Andrea Yates where she was convicted, there was revulsion that Texas had too narrow an insanity defense, it ought to have been broadened. So this is much at the whim of political changes as we get tough or tender, as the case may be. Because remember again, it's a moral and legal issue, it's not a scientific issue. We can be tough or we can be tender using the exact same test. So it seems to me the real question of the future is, in addition to what will mores in society bring, but will the Supreme Court ultimately hold that it is constitutionally required? And I would like to say that I think it is. Since the early 1800s, we have had an insanity defense everywhere in the United States, with rare exception. It's part of our history, for those of you who are attracted to historical arguments. It instantiates a basic moral value. The states that have abolished are simply wrong. They're not doing good morals, and they're not doing good politics, and they're doing even worse law. Thank you.
Good afternoon. Before I assume character as Judge Richey, I just want to thank Steve Pollak and Eric Dubelier and Jeff Kleinberg and others for inviting me here. It's a real pleasure to be here. And I know Judge Richey would be really thrilled to see one of his cases reenacted so many years later. He was quite a character for those who know him or knew him, and he gave the lawyers a real workout in this particular trial, and we'll do our best this afternoon. But I can't pretend that I can imitate Judge Richey's persona on the bench. But with that, let's begin. So we'll hear argument today in criminal case number 94-447, United States of America versus Francisco Martin Duran. Before I ask counsel to address a central issue in this case, namely whether Mr. Duran was insane when he shot into the White House on October 29, 1994, let me briefly summarize the evidence presented at trial. In the early afternoon of October 29, 1994, after spending about 6 hours on the sidewalk adjacent to the White House, Mr. Duran shot approximately 30 rounds from an assault rifle into the White House grounds, where a group of men in dark suits were gathered, including one Dennis Basso, who resembled President Clinton. Immediately prior to the shooting, 2 witnesses testified that they heard someone say that President Clinton was on the lawn. After Mr. Duran stopped to reload his rifle, an onlooker, as we saw, tackled him, and soon thereafter, the Secret Service arrived to help subdue Mr. Duran and confiscate the rifle. Searching his truck after the arrests, agents found another rifle, several boxes of ammunition, a letter in which Mr. Duran had written, quote, "Can you imagine a higher moral calling than to destroy someone's dreams with one bullet?" A road atlas on which Mr. Duran had written, quote, "Kill the Prez," a cover torn from a telephone book bearing a picture of President Clinton, which Mr. Duran had defaced by drawing a circle around President Clinton's head with an X through it, as well as other incriminating documents. Mr. Duran was charged in a 10-count indictment with attempting to assassinate the President of the United States, as well as violating a number of other federal criminal laws. Mr. Duran's counsel argued that he shot toward the White House not with the intention of killing President Clinton or anyone else, but with the intention of attracting fatal return fire from security agents. Doctors presented by the defense testified that Mr. Duran suffered from paranoid schizophrenia and that he shot towards the White House with the intention of eliminating a so-called evil mist that he believed was hovering there. We heard evidence from the defense that after he was dishonorably discharged from the Army, Mr. Duran, a lifelong Catholic, changed his religion, became interested in ways to leave his own body, something he called astral projection. He began to hallucinate and describe himself as God and Jesus Christ, and then to focus on the mist that he believed controlled the government. For its part, the prosecution presented 2 witnesses who testified that Mr. Duran hated the United States government in general and President Clinton in particular. The government introduced evidence that Mr. Duran made 3 separate purchases of an assault rifle and ammunition, and that on his travel from D.C. to Colorado, he purchased an additional ammunition clip and a trench coat that he wore on the day of the shooting. The government also presented 3 doctors who testified that Mr. Duran was faking his symptoms of mental illness and suffered only from a personality disorder, narcissistic and antisocial personality disorder, that did not substantially affect his capacity to appreciate the nature and quality of the wrongfulness of his conduct within the meaning of the Insanity Defense Reform Act of 1984. All right, with that introduction, because the defense bears the burden of proof on the question of insanity, the court will hear first from Mr. A.J. Kramer, the federal public defender for the District of Columbia. If you would please focus your argument on the elements of the insanity defense and how it's your position that Mr. Duran has met his burden by clear and convincing evidence.
Yes, Your Honor. Folks, Had you been with Mr. Duran on the morning of October 29th, you would have seen him get up at his hotel in Virginia about 6 in the morning. You would have seen him, like the good soldier that he was, proceed to the White House, go to the White House, and take up a position there like a sentry to protect the seat of government in the United States from the forces that were trying to take it over. Mr. Duran thought that he could prevent this takeover of the White House and of the government by this evil mist in this cloud that hovered over the White House. If you had been there with him early in the morning of October 29th and suffering from the paranoid schizophrenia that he suffered from and from the delusions that Mr. Duran saw, you would have also seen those satanic forces that were threatening the government of the United States and the White House. You would have known, as Mr. Duran knew in his mind, that the government agents kill and cover up to maintain power. You would have seen his hallucinations to this effect, and his hallucinations of out-of-body experiences, and embryos splitting, as you heard the doctors describe Mr. Duran's delusions. And you would have heard, and you would have known about the world Mr. Duran lived in and how he grew up. Let me just go back for a minute and tell you about Mr. Duran's life as you heard it. He grew up in a small town in Colorado. He was one of 6 children. 2 of his sisters died when they were babies. The family was, he never knew who his father was. The family was fairly poor, but Mr. Duran persevered, graduated high school in that small town, and as soon as he graduated high school, he signed up and enlisted in the military. He wanted to serve the United States and serve his country, and he did that honorably, as you've heard, for a number of years in the military. He was stationed in Hawaii for a period of time, and again, you heard a lot of his people he was in the service with at the time come in and testify and tell you what a fine soldier he was in the Army, and then there was the incident in the bowling alley you heard about. And you heard about the incident in the bowling alley, and as a result of that, Mr. Duran ended up getting sent to Fort Leavenworth for several years, and that's where the downward spiral in his life began. But you would have seen on October 29th the strange things Mr. Duran went through. There is the little box, the things he did to prepare. There's the little box of injectors that you saw. Very strange item to have. Mr. Duran had a box of antidotes to lethal gas in his truck with him that day, and he thought that he would be able to resist as long as possible before dying on behalf of his country and rescuing the White House from the forces trying to take over. And so he had this box of injectors. The government has made a big deal out of how he deliberately went and bought the rifle that was used and how he went and bought the ammunition. But you saw he bought boxes and boxes of ammunition. This was not the workings of a mind carefully calculated to assassinate the president. This was a very sick mind that bought boxes and boxes of ammunition to protect against the evil forces that were trying to take over the White House in the mist.
Let me just interrupt you there, Mr. Kramer.
Yes, Your Honor.
He did purchase firearms. He went cross-country, made various stops. He transferred his credit card balances to ensure that he would have sufficient funds, both for the trip from Colorado to D.C. and back. He purchased ammunition. He purchased a trench coat. This looks like a situation where he had plans carefully calculated and he carried them out. And I think the government's position is that this is a competent person. So how do you reconcile that version of events with your position that he was so mentally ill, so severely mentally ill, that he basically could not distinguish between right and wrong?
Well, 2 things. He is competent, but that's a different test than sanity or insanity under the law. The second thing is our doctors testified clearly that people can exist in society, get along with society, run daily errands, run their lives, control their lives, and still be seriously mentally ill. Especially people paranoid schizophrenics can function in many ways and appear normal until someone talks to them and learns the depth of their delusions and of their thinking. So I think that's the simple answer to that.
Well, let me ask, you mentioned the doctors. Let's talk a little bit about the doctors. We have competing expert opinions here. We have various doctors staking their professional reputations on competing diagnosis. We have paranoid schizophrenia from the defense witnesses, and then from the government we have antisocial or narcissistic personality disorder. If the jury either believes the government or just can't decide, doesn't the burden of proof under the statute mean that you lose on insanity?
Well, sure, we have the burden of proof to prove it by clear and convincing evidence, yes. And of course, that comes down to, I think, several things: who the jury believes which experts the jury believes are more credible, and also what there might be support for in the external evidence that might support their opinions. And we obviously think that the other evidence in the case supported our doctor's opinions better than those of the government. So
what's your best evidence? And we know that he had a sad upbringing, that he had a troubled marriage, he was upset about being discharged dishonorably. He has a sad story. Well, what's your best evidence aside from the doctors then that should persuade the jury that this man was so sick that he didn't appreciate the nature and quality and wrongfulness of his actions on that day?
His life and beliefs began to change dramatically while he was at Leavenworth, imprisoned at Leavenworth, as the juries heard about how his religious beliefs began to change, how when he went back to Colorado after that, his family life changed, his delusions started to appear, and then as he came out to Washington, D.C. So I think all of that evidence. And the way he did the offense by buying these huge boxes of ammunition, by having these lethal gas antidote injectors that he had in his truck with him, a large box of them in his truck as well.
Thank you.
Let me tell you, folks, about when he was at Leavenworth. You heard, and he was until then a very strict Catholic. At that time, he changed his religion to become a pagan, a Wiccan, he called it, and various other beliefs that are certainly not in the mainstream or not unknown to people. And then it was when he was released from Fort Leavenworth, he went back to Colorado to live with his family. And he and his wife, he had met her in Hawaii. They had a little boy. He went back and he got a job at the Broadmoor Hotel, a very fancy resort, as you've seen, and you've heard from a number of his co-workers, who testified that Mr. Duran kept mostly to himself in a furniture shop, but he started to say very strange things to them. And he started to listen. He was listening at the time to very far-out conservative radio programs. A man named Rush Limbaugh and a man in Colorado named Baker was what he would listen to in his shop all day. And then he started to tell people, "I am God." So things started to get very strange at the Broadmoor, and then he was very close to his child all the time they were in Hawaii and when he first came back. And then he started to get very distant from his family. And one day he just packed up without leaving, got in his truck, it was 1 month from his birthday, from his son's birthday, packed up his truck, and you remember about a month before this, a small plane had crashed in the White House and the pilot had been killed, flown into the White House. Mr. Duran believed that plane was drawn in by the evil forces, and he went there to try to rescue the White House and the government from these evil forces and the mist that hung over it. And you've heard the doctors. Dr. Shretlin, the psychologist, actually sent out the psychological test of Mr. Duran to 3 other doctors who all agreed with him that Mr. Duran was a paranoid schizophrenic, that he suffered from these delusions, that these delusions were real. And you know that on his way out to Washington, Mr. Duran stopped in San Antonio, which is very important because 2 of his closest friends from the military were there. Pete Martinez was there, and another soldier that he served with in Hawaii was there, Sergeant Beatty. And you know they were 2 of his closest friends and talked about what a great soldier he was. So he sets out to the White House to try to rescue the White House and the government from this evil mist and this evil cloud taking over the White House. And he was there the day before, He was there the next day, walking almost like a sentry around the White House and taking up guard duty around the White House. And Mr. Duran then started open fire. And you'll see, you've seen where the bullets landed. And a number of them went at the roof line of the White House, which is exactly where Mr. Duran said the mist and the cloud hovered over the White House. And this is not the actions of a normal person, folks. This is a severely disturbed man suffering from a severe mental illness, paranoid schizophrenia, as all of our doctors have agreed upon, and the doctors Dr. Shretland sent the tests out to agreed upon, that Mr. Duran is severely mentally ill from paranoid schizophrenia, that he had delusions that the White House was being taken over by this evil mist and evil cloud as the people in it and the people in power in our government, and that he was there to rescue the government. And that's what Frank Duran believed he was doing on October 29th, rescuing the government of the United States and being the good soldier that he was. Thank you.
Thank you, Mr. Kramer. The court will now hear from Eric Dubelier on behalf of the United States.
May it please the court, ladies and gentlemen of the jury, there are two questions that you need to answer in this case, and the questions are relatively simple. First, do you believe Duran thought that Dennis Basso was the President of the United States? And second, is Duran insane? If you answer the first question yes, and you answer the second question no, Duran is guilty of everything he's charged with in the indictment. Let's briefly recap the evidence. Duran told multiple witnesses that you heard from at this trial that he hated the U.S. government as a result of his court-martial in the military, as well as hating the President of the United States. He began, when he was living in Colorado, buying firearms, ammunition clips, and he ultimately bought the rifle he would use in the attack on the White House. He traveled cross-country. He stopped. He stayed in hotels. When his charge card was cut off, he got on the telephone with the charge card company and got it turned back on. He bought additional firearms. He bought additional ammunition. He bought a folding stock for the rifle, and he bought a trench coat that he would wear during the attack. Witnesses who dealt with him on this trip across the country, clerks who sold him goods, hotel people who rented rooms to him, said he appeared to them to be completely normal. He comes to D.C. and he checked into a hotel, and he lived here for several weeks. He floated bad checks in order to pay bills. He tried to pick up a woman. You heard testimony from a woman that he tried to pick up in a hot tub at one of the hotels that he was staying at. The day of the attack, he spent 8 hours on the sidewalk in front of the White House with that rifle under his jacket, and he waited until the moment that Dennis Basso, who you've seen pictures of, you've heard testimony from, looks remarkably like President Clinton, stepped outside of the White House.
Mr. Dubelier, let me interrupt you there. Isn't it true that just because he can function on a day-to-day basis doesn't necessarily make him sane, right? We have someone who, as you said, stood outside, I think it was an 80 to 85 degree day, we heard testimony to that effect, in Washington, D.C., with a trench coat, with a firearm hidden under the trench coat, and then pulls it out and puts 30 rounds of ammunition into the White House. I mean, isn't it fair for a jury to conclude from that that this guy is crazy?
Well, the jury, it is reasonable, I think, to at least start with the question, wouldn't someone have to be crazy to do something like this? And my answer to that really is simple and straightforward. There are a lot of people who commit crimes who aren't very smart, and there are a lot of people who commit crimes who have personality problems. It doesn't make them insane under the law. People do foolish things. Although, if you look at the facts of this particular case, ladies and gentlemen of the jury, this may not have been such a foolish thing that he did. He wanted to kill somebody. If you want to kill somebody, what's one way to do it? Go to their house and wait till they come outside. And that's exactly what Duran did on this day in October 1994. Now let's talk about the doctors called by the defense, because it is the defense's burden in this case to establish Mr. Duran was insane. Let's start with Dr. Blumberg. Dr. Blumberg, based on the testimony you heard from him, would have said anything to help this defendant. He actually read a script on his direct examination. The defense lawyer would ask a question, he would look down at the piece of paper and read the answer into the record. On cross-examination, he refused to answer almost any question I asked of him. He ducked every question. But then remarkably, towards the end of his cross-examination, he testified that Duran told him, when he interviewed Duran, that Duran told him that he had told others in Colorado, as you heard from those witnesses in Colorado, that he was going to kill the president. And then remarkably, ladies and gentlemen, you may remember, we had a break in Dr. Blumberg's testimony overnight. He came back and testified on redirect the following day, and he changed his testimony. And he denied that Duran ever told him that Duran had told other people that he intended to kill the president. Let's talk about Dr. Shretlin. You may remember Dr. Shretlin. He was the guy with all the charts and the graphs. Now, he admitted to multiple errors on these charts that he showed you. We pointed out errors on the charts, and he admitted he had made mistakes on these charts. He cited to studies that we went back and found these studies, they had only been published in the Chinese language. And when we pointed that out to him, he admitted that he had never read the studies. He testified that his test results, the tests he had given Duran, established that Duran was suffering from paranoid schizophrenia. But he read the test results and analyzed them in a way that is contrary to the instructions from the people who actually created these tests. All Shretlin knew how to do was to make up some foolish charts that he tried to fake you out with, the same thing Duran is doing. Dr. Rappaport, yes, Your Honor.
Government's witnesses testified that this man had some mental disorder. He had some pathology. So how is the jury to determine a pathology that qualifies under the statute and that does not? Say the jury decides to believe the defense witnesses that he was a paranoid schizophrenic. Does that mean that this insanity defense, the burden's been carried on insanity and that he is insane? I mean, how is the jury supposed to parse the distinction between a qualifying illness and a non-qualifying illness?
The critical evidence on this point is the testimony of Dr. Phillips and Dr. Patterson, the two government experts who testified and told you that Duran suffers from antisocial personality disorder and that he's a narcissist. So what we need to do is we need to boil that down, ladies and gentlemen, to common sense. Let's put that in layman's terms, common sense, antisocial personality disorder. What does that mean? Simply, he can't fit in. He can't live in our society without getting in trouble because he wants to do things his way. He wants to do things by his rules. He's a narcissist. What does that mean? He needs attention. He wants people looking at him. He wants to be somebody. He's a wannabe, and that's why he did this. His hate and his anger. These personality traits have nothing to do with whether or not Duran was unable to appreciate the nature and quality or wrongfulness of his acts. So let's go to Dr. Rappaport, who was the second defense witness, a highly acclaimed forensic psychiatrist. I started out, you'll recall, in questioning Dr. Rappaport by pointing out to him certain things that he had written in professional journals. The first quote, and you'll recall, ladies and gentlemen of the jury, he got very angry with me, is he wrote, and he admitted that he wrote, that in close cases he is biased in favor of the defendant. He admitted to that. And you saw where he wrote that. I also showed him a second quote. Quote, these are Dr. Rappaport's words. Psychiatry is an inexact science. Often the decisions we render are no more than just an educated guess. And when I pointed these quotes out to Dr. Rappaport, how did he react? Did he try and explain it away? No, he got angry with me. He raised his voice at me, and what he said is, I didn't write these things for you. I wrote these for my medical colleagues. Well, ladies and gentlemen, Dr. Rappaport is just a man, like any one of us. He happens to have a medical degree. I can read and understand what he wrote. You on the jury can read and understand what he wrote. And importantly, on cross-examination, Dr. Rappaport in fact admitted that Duran told him he hated the government and Duran told him he wanted to kill the president. Now, according to Mr. Kramer, Duran believed he was going to die. Maybe, maybe not. So what? You've heard testimony that Duran was a pagan, that he thinks death is part of life, that he's not afraid to die. Ladies and gentlemen, he's a lucky guy. Wouldn't it be nice if we could all say that? We're not afraid to die. That doesn't make him psychotic. It makes him at peace. He doesn't have to worry about it. The injectors, you heard Mr. Kramer talk about the injectors and you heard about the testimony about these injectors. You've seen pictures of these injectors. The injectors were garbage that were in the back of his trunk. The injectors, the doctor said he took the injectors to inject the mist over the White House. That's what the doctor said Duran told them. If so, why didn't he have the injectors in his pocket when he went out on the sidewalk in front of the White House? This is ridiculous. Now the defense changed the story, and they claim he had the injectors in the car, so if he beat the mist, he could run back to the car and stick himself with the injector to save himself from dying from the mist. Ladies and gentlemen, it's ridiculous. The defense says that Mr. Duran had, quote, some problems, end quote. Some problems, you heard the testimony about his problems in Colorado. He was cheating on his wife. He was running up charge bills on a 900 sex telephone line. He was running around buying guns. Ladies and gentlemen, that's a little bit more than some problems. He didn't leave Colorado chasing a mist. He left Colorado because his wife was screaming about him about the telephone bills and the calls to the 900 sex lines. Astral projection and change of religion and all that stuff, is that stuff odd, ladies and gentlemen? Maybe, maybe not. You heard testimony about a Rorschach test and how Mr. Duran, looking at that test, established that he was paranoid, he was a paranoid schizophrenic. I'm not going to spend a lot of time on this because it is some doctor trying to tell you that they can look at a bunch of ink slapped on a piece of paper and tell you whether or not a man has a mental disease or defect. Have you ever heard of anything so ridiculous? The defense claims Duran was not firing at Basso. Instead, Duran was firing at a mist over the White House. Let's focus on that, ladies and gentlemen, because to acquit Duran of count one, you would have to do certain things. First, you would have to ignore the testimony of the eyewitnesses who said he started firing the gun the instant someone out there on that sidewalk pointed at Dennis Basso and said, look, there's President Clinton. But second and more importantly, you would have to believe in the greatest coincidence of all time. And that coincidence is the mist that Mr. Duran has talked to you about was following Dennis Basso. Maybe the mist was confused. Maybe Basso looked so much like the president that the mist was following Basso, and that's what confused Duran. So when he started firing at the mist, he thought was going to get Basso, who he thought was actually the president of the United States. Ladies and gentlemen, do you want to believe this fairy tale? Forget it. He stood out there all day long and he didn't start firing that gun until the second Basso stepped outside. And the defense wants you to believe that he wasn't firing at Basso, that he was firing at a mist. Ladies and gentlemen, finally, to find Mr. Duran not guilty, you would have to believe that the government doctors are wrong. You would have to believe that Dr. Patterson and Dr. Phillips are wrong when they testified that he is faking mental illness. That's what they testified to. There is a motive here, ladies and gentlemen. The motive is this man was angry at the government. He was angry what happened to him in connection with his court-martial. Is he insane? The answer is no. It is no because Dr. Phillips told you the answer is no, and it is no because Dr. Patterson told you the answer is no. And Dr. Patterson testified it took him 3 hours of observing Duran to figure out he was faking. Yes, he has personality disorders, but the story about the mist is fake, and it's made up by Duran in an attempt to escape responsibility for what he did. Ladies and gentlemen, he was guilty as charged of all the counts in the indictment, and we respectfully ask that you find him so. Thank you.
Thank you. Thank you, Mr. Dubelier. Thank you, Mr. Kramer. For the benefit of the audience, I can tell you that once charged, the jury in the Duran case deliberated approximately 5 hours and returned guilty verdicts on all 10 criminal counts in the indictment, including attempt to kill the President of the United States, assault of federal officers with a deadly weapon, unlawful possession of firearms, destruction of federal property, and use or carrying a firearm during and in relation to a crime of violence. The court sentenced Mr. Duran to 40 years in prison. In October of 1996, the D.C. Circuit affirmed the conviction in an opinion authored by Judge Wald, and Mr. Duran is currently serving his sentence at the medium security Florence Federal Correctional Complex in Colorado. He's projected to be released in 2029.
Okay, you've met everyone on our panel except for Dr. Canavan, who heads St. Elizabeth. And I'll ask you the first question. If Congress achieved its objectives so well, then fewer criminal defendants should be going to places like St. E's these days, right? Is that what's happening?
It is, in fact. Business is slow as a result of some of this activity that we've seen. There are two things that happen. One is the federal system started to send detainees into the federal system. So Butner, North Carolina, principally for defendants such as this, or individuals who have been found not guilty by reason of insanity under the U.S. Code. So that did reduce the number at St. Elizabeth's itself. We do still have 10 USNGs in our care currently as inpatients. We have 11 that are outpatients. But generally, we've seen a real diminishment in the number of people who've been found NGI, either through the D.C. Superior Court or through USNG.
So conversely, that means more defendants are going to prison?
Correct. Fewer people are attempting this as their plea, and fewer of them are being found NG.
In his instructions to the jury, Judge Richey said that non-psychotic behaviors and disorders, such as patterns of antisocial conduct, are not considered severe mental diseases or defects. But he didn't define psychotic, okay? Where is the tipping point? What does that mean? Let me go to Professor Morse.
You know, just to establish bona fides for a second, I'm a board-certified forensic psychologist as well as a lawyer, so I feel qualified to comment on this question. By and large, psychosis or psychotic refers to a state where someone is out of touch with reality, grossly out of touch with reality. And the idea was, with the Insanity Defense Reform Act, of using the qualifier severe for mental disorder, is to exclude people who, although they may have actually quite serious problems, are really in touch with reality. So we can expect them, despite their problems, to fly straight. People who are really wildly out of touch with reality are the sorts of people who don't deserve blame and punishment. Now, as a practical matter, in the insanity defense nationwide, unless the defendant was psychotic, he or she will not win with the insanity defense. Now, being psychotic alone does not mean you will win, but unless you are psychotic, you probably won't.
Well, why not then simply make the test, the insanity defense test, whether or not you're out of touch with reality?
You mean the second prong, knowing right from wrong, or not knowing the nature and quality of your act? Because what we think is you could make such mistakes, you could not have such knowledge, but it would be a product of your own deficiencies, your own lack of attention to the rules, or things like that. The notion of tying psychosis to it is the reason you don't know those things is because you're out of touch with reality.
But isn't that where Mr. Dubelier and Mr. Kramer essentially disagree, whether or not Duran was out of touch with reality? Wouldn't that have worked as the test?
No, because even if I think Mr. Dubelier got it right in his very opening part of his concluding argument. Even if Duran had been psychotic, it is still not necessarily the case that he would have satisfied the could not appreciate the nature and quality or the wrongfulness of his actions. Some people who are psychotic can, and even if they're psychotic, they get convicted.
Okay, Mr. Kramer, did Mr. Dubelier get it right?
No, not in any respect. It was a very difficult case in the sense of Mr. Duran had no prior history of treatment for mental illness or having gone to seek any help or counseling for mental illness. So, but it was based on the, as you saw that videotape, an alibi defense was kind of out of the question. A duress defense was kind of out of the question. And I didn't do it, it was the person next to me was out of the question. So, but the insanity defense was based primarily, well, it was based on the doctor's testimony, which said that our doctors supported Mr. Duran's severe mental illness and the inability to appreciate the nature and quality of his acts. In fact, said that he thought he was doing the right thing. And the other thing is, we called a lot of his witnesses from the Army, his family, people he'd been in the Army with, and people he worked with at the Broadmoor Hotel, who said that he had changed dramatically, his personality had changed dramatically. So we tried to support it that way, too.
You just left out one word, though. You left out the word serious. okay? A serious mental.
Our doctors diagnosed him as paranoid schizophrenia, which they said is a serious mental illness.
Well, the judge did not define, I looked at the jury instructions, didn't define serious. Should he have?
Well, the government doctors did not disagree that if he was a paranoid schizophrenic, that's a serious mental illness. They disagreed that he was a paranoid schizophrenic. So there wasn't really any disagreement that if he was a paranoid schizophrenic, he suffered from a serious mental illness. The government doctors just said he didn't suffer from paranoid schizophrenia.
Well, we've been told, though, that the ultimate issue here is for the jury to decide and not for the experts to announce to the jury. Shouldn't the jury have some understanding of what it means when you say serious?
Let me put it this way. In this particular case, it didn't bother us because the government doctors had not disagreed that if paranoid schizophrenia was a serious mental illness. So the government's argument to the jury was not that he did not suffer from that he was paranoid schizophrenic, but that's not a serious mental illness. Their argument was he was not paranoid schizophrenic, period, and he didn't have a serious any mental illness.
Mr. Dubelier, you're not going to argue, of course, that he was suffering from a trivial mental disease or defect. You're suggesting he wasn't suffering from one at all. Is that right?
Well, I actually think our view was it didn't matter if it wasn't a serious enough of a mental problem where he could not appreciate the wrongfulness of what he was doing. I think what made this case particularly complex, and I think very complicated for AJ in his defense, the primary charge here was a specific intent crime. We had to prove that he specifically intended to kill the president. So you have to figure out, well, if that's what we have to prove, how are you going to reconcile that with an insanity defense? Are you going to say, well, he intended to kill the president, but he didn't understand the wrongfulness of that? And so really the way the defense moved, I think, because that wasn't going to be something that I think was viable to the jury, is that he was shooting at the mist instead of shooting at the president to try and remove that problem.
Well, you can form the specific intent to do something and still think you're doing a good thing. Is that Mr. Kramer is telling us that his client believed that his client was acting heroically.
Well, not heroically trying to kill the president, heroically trying to kill a mist that was floating over the White House that happened to be there at the instant that our dead ringer for President Clinton stepped outside, Dennis Basso. And I think, that was remarkably powerful evidence. AJ can address this from his view, but Dennis Basso looked remarkably like Bill Clinton. Same height, same build, in a nice business suit, same hairstyle, same hair length. And you're talking 50 to 60 yards away. Men in business suits and a little kid out there on the sidewalk pointing and going, there's President Clinton. And at that instant, after 8 hours, that's when Duran ups with the rifle and starts firing. To AJ's point about some of the bullets going along the roof line, I think the first shot went about a foot over Mr. Basso's head and lodged itself in the wall of the White House near the press office. So as he ran down the sidewalk, the arc went higher, but those initial shots were very, very close to Mr.
Professor Morse?
I've not read the transcript and I didn't hear the testimony, but as I'm listening to it, I think there was a failure probably on the part of the defense psychiatrist, which is this. On the one hand, you have seemingly clear evidence that he had this delusional belief about the mist, and that looks pretty crazy. On the other hand, there's very straightforward evidence that seems he wanted to kill the president and acted in ways, as the questions in Mr. Dubelier have suggested, don't look so crazy at all. What I think was necessary in this case was explain to the jury how someone who's suffering from a psychotic mental process could have woven those two things together in his mind in some coherent narrative that would make it seem that the attempt to kill the president was part of a broader plan. Now, that might have been very, very hard to do. I didn't examine Mr. Duran, and I don't know the evidence, but that was what was needed to be done because there was just too much quote-unquote smoking gun evidence with the president if you didn't weave the president into psychotic delusions. And that's what needed to be done, and I don't think was done.
Well, or he could have been faking it.
Or he could have been faking it. That's the alternative story.
Right?
Sure.
Or,
and by the way, there is no blood test, there's no brain test for whether someone is malingering. Mental illness is still today, in 2012, in the era of the brain and the gene, diagnosed and evaluated purely behaviorally. Thoughts, feelings, actions.
Well, let's ask our psychiatric expert Dr. Canavan, was, in your judgment, Mr. Duran suffering from a severe mental disease or defect, but he just couldn't prove it?
I have no idea. I mean, honestly, unless you were part of the whole evaluation, I think it's very tough to analyze. The lawyers did a very good job of taking apart the other experts' opinions on these matters. But what I would say is that as a result of this, some of what occurred was a real diminishment, I think, and a tendency to blame the mentally ill. And this NGI, this whole concept of NGI is something that, it's a big concern to me, that public opinion around the not guilty by reason of insanity plea is that that's somehow a way to get off easy. When in fact, I think they're just wrong on the facts, which is, often a not guilty by reason of insanity finding ends up being a life sentence for many people. And it's the term that a person would serve as a result of that plea being found is quite difficult. And I think part of what my concern about the case and other changes that occurred in the law was that pendulum swinging. If Dr. Morse said there are those who do wrong and are not morally responsible, where are we in the pendulum swing around that? And how do we best define what is proper for them? One of the results that we know, and I see it in the DC Superior Court all the time, is that the number of mentally ill individuals who end up being charged criminally is huge. And those people end up receiving treatment only in correctional facilities. And I don't think that it's the type of treatment that any of us as a society really believe is the appropriate treatment for them.
So you're saying Congress did not do anything helpful?
Well, what I would tell you is that when the LA County Jail is the largest mental health provider in the country, that there's something wrong.
Mr. Dubelier?
I think it's an important point. I can't speak to what happens in LA, but here in DC, shortly after the Duran trial, a man named Leland Majeski jumped the fence of the White House. And he had an inoperable firearm. He had an altercation with the uniformed division officers there, and one of them was severely injured because the one officer went to shoot Majeski and in fact shot one of the other uniformed officers. We stipulated that Majeski was incompetent, and then we stipulated that he was not guilty by reason of insanity. There was no question about it. Mr. Kramer's office represented this man. He was clearly psychotic. And in fact, my recollection of this, and it's 16 years ago, we even agreed with AJ's office on a single expert that was going to evaluate him and figure out a treatment plan for him. So I think this system did work. And that's a very stark example of not the exact same conduct, but similar conduct where there was no question in our mind, in our discretion as prosecutors, that the man was psychotic.
Let's follow up, though, on Dr. Canavan's point. If Duran had been acquitted by reason of insanity, where would he be today?
Most likely in the federal system, I believe.
And what care, treatment, if any, would he be receiving?
In Butner, North Carolina, my understanding is that the behavioral health hospital for the federal system is a quite good hospital. And so he'd be receiving probably a very individualized treatment planning process where he'd participate in groups. I can tell you at St. Elizabeth's, our treatment is very extensive and people receive really solid treatment 20 hours a week for sure, where they're in groups, where they are evaluated routinely, where they are given opportunities to exercise privileges, where they're given the opportunity to participate with other people in curative activities.
So he's receiving first-class care, and he's ultimately going to be released, or what's going to happen?
Well, I can't comment on Duran. I don't know.
Right.
At St. Elizabeth, someone similarly situated certainly would have the ability to go before the hospital's internal review board and receive certain levels of privilege. Eventually, if they're compliant with their treatment planning, if they're able to really participate in treatment, if they're following the recommendations of their treatment team, if they're displaying really pro-social behaviors, they would then want to approach the court and ask for a conditional release, which certainly about 2/3 of the individuals who are not guilty by reason of insanity at St. Elizabeth's have some level of privilege.
Yes, Professor Morse.
A couple of things. On the plea agreement, nationwide, many insanity defense cases are resolved by plea agreement. So it's not just in federal cases, in states as well. You get an obviously psychotic defendant, and no one wants to go to the bother. What Dr. Canavan said is true. On average, people acquitted by reason of insanity spend about as much time in a secure forensic facility as they would have spent in prison for the crime charged. Now, there's some problems with those studies, but that's a rough and ready estimate, although it is also true that the Supreme Court has approved indefinite lifelong commitment if you're acquitted by reason of insanity. As a matter of the United States Constitution, the Supreme Court has held if during the course of that commitment you are no longer mentally ill or no longer dangerous, it's disjunctive. You're not mentally ill, you shouldn't be in a hospital because you're now responsible for yourself. You're no longer dangerous, you don't need to be locked up. Even if you're still mentally ill, you must be released. So if someone with serious mental illness is getting the very good kind of treatment that Dr. Canavan talked about, there's a very substantial likelihood that they might recover and get released.
A major component of the current scheme is that we've eliminated diminished capacity, would you say?
Well, there never was a diminished capacity defense in the United States. Even the Twinkies defense in California was not, which California got rid of in 1980, and there was no Twinkies defense, by the way. The real question was, were defendants going to be allowed to use evidence of mental disorder to negate the mental state required by the definition of the crime, to negate mens rea? Because I was crazy, I didn't intend to do what I did, like shoot the president or something of the sort. That was often confused with a different claim. I may not be legally insane, but my elevator doesn't go all the way to the top and I'm not fully responsible for myself. Courts constantly confuse those claims. In current law, in a vast majority of the states, you can use evidence of mental disorder to negate mens rea. That's sometimes called diminished capacity, but it shouldn't be called diminished capacity. We're all lawyers, we know that. You can't meet the criteria for the crime charged, you didn't do it. That's no special offense. It's just a straightforward application of how crimes are defined.
Hasn't there been, though, a thrust to move that question of, diminished capacity, irresistible impulse, whatever, to the sentencing phase rather than to the initial merits phase?
It's moved in the other direction because there's been, since the 1980s, much more extensive use of mental disorder to negate mens rea nationwide. There's been, since Hinckley, real disfavoring of irresistible impulse. Now, when you use it at the sentencing phase, that's where you're saying, look, even if you prove the elements, so you prove the crime against me, still, I wasn't fully rational, I wasn't fully normal, I'm not fully culpable, give me a lesser sentence. That has happened. Certainly in death penalty cases, it's a classic mitigator.
Mr. Kramer, to what extent has this provision in the rules of evidence that changed in '84 made it difficult for a defense lawyer to show or to get an expert to say my client was crazy?
Well, to get an expert, it has not made much difference. The problem is, I think, that it's used far less frequently for a couple of reasons. First of all, because the burden of proof is now clear and convincing. It used to be the government had to prove sanity beyond a reasonable doubt, and if they did not, the defendant walked out the door, they were just acquitted. Now there's this not guilty solely by reason of insanity verdict, which is either Dr. Morse or Dr. Canavan said, results in the commitment of the defendant for sometimes longer than the sentence. So I think that you got to remember this case was an attempted assassination of the president, which carried a life sentence. In fact, the government argued for a life sentence. It's sentencing. So there wasn't the concern that the commitment might be for a longer period of time than the likely sentence at the end of the case. We felt we couldn't go with a defense that admitted that he was trying to shoot the president, that would fly even less successfully than the defense we put on. But I think that it's not used very often. It's stipulated a number of times, the insanity defense now, when both sides, but it's not used very often by defense lawyers anymore because of the change in the burden of proof, and it's so hard to prove, and because of the consequences that might result in a far longer commitment than a simple guilty verdict.
Focus on one word, which is unable to appreciate nature, quality, and wrongfulness. Unable. Should the psychiatrist be able to state whether or not, in his or her expert opinion, the defendant was unable to appreciate, et cetera?
Should they? Yes. Can they? No, under the federal rules as they are right now.
Has that handcuffed you?
Sure. I mean, it's a very strange thing to have to to get all the testimony out that it's a serious mental illness and why the defendant did what they did as a result of that serious mental illness, and then not have the doctor be allowed to say the ultimate issue, which now the defense has to prove beyond a reasonable, by clear and convincing evidence, and not have any doctor be allowed to actually say those words. In the previous regime, if the government had been so handcuffed that they would have never been able to prove beyond a reasonable doubt.
So the Congress go too far, mean-spirited.
Well, there was a lot of reaction to the Hinckley verdict, and that Congress did what they did. Now, whether you agree or disagree with that is a whole other issue.
Okay, I saw two hands. Mr. Dubelier is
Well,
first.
I think AJ made a very important point when he answered your question. Is it more difficult now to find experts? And he very quickly answered no. Now, we had very prominent experts in this case on both sides, and their opinions were at polar opposites. And I criticized in cross-examination as well as attacked in closing argument Dr. Rappaport, arguing that he had written, oh, this is all just a guess anyway. You know, we don't really know. It's not, to Stephen's point, it's not like diagnosing cancer. A radiologist is going to look at a picture and say, this person has a tumor and we're going to biopsy it and it's benign or malignant. This is educated guessing. And although I made fun of Dr. Rappaport about that, he wrote it, he's the expert, maybe he's right. And that, in my mind, creates serious questions about these battling of experts. It basically comes down to who can you dress up the best and convince the jury? Because that's what it comes down to. They all have the same credentials, they all have the same background and education, and then they get up there and you dress them up, and who's the jury going to believe?
I have to do some special pleading. When I testified before Congress on behalf of the American Psychological Association about the Insanity Defense Reform Act, I strongly urged, and I think I was the strongest urger, that ultimate issue testimony be excluded. But I don't think it's because I'm mean-spirited. As you can tell from listening to my remarks, I'm a great fan of the insanity defense. The reason is because experts simply don't know whether the defendant is unable or not. And ultimately, that's the legal conclusion that the jury or the judge has to reach in a bench trial. And so therefore, just put out all the clinical testimony and then let the jury decide, because there's no scientific test for unable or not unable. It's a common sense conclusion, and it's a legal conclusion, and jurors can draw it as well as experts.
Well, is the jury as able to decide that as an expert?
I think they are, and indeed they're not as schooled in coming up with a diagnosis. That's not what jurors are expected to do. They're not as schooled in a very deep clinical evaluation of a defendant's behavior. Experts are much better at doing that, but reaching the ultimate legal conclusion is an ultimate legal conclusion. And as I said, when the expert gives the ultimate legal conclusion on either side of the aisle, they've stepped out of the witness box and they've stepped into the jury box.
Dr. Canavan, you were not a juror in the Duran case, but you've heard the evidence here today. Was justice done in the Duran case, or was it not?
I have no idea. I have no idea. I would just say that
It was.
Yeah, the idea of the ultimate answer here, I think, is correctly rests with the jury. You know, psychologists, psychiatrists should serve we're serving the court, really. We're in the interest of trying to get closer to the truth. And a good expert is going to be able to explain things in common language such that reasonable people could make a good conclusion. And the job of the expert is really to serve the court and to serve, furtherance of truth here. So coming up with the ultimate answer is not the job of the expert.
Would Mr. Duran at any point, had he been placed in a mental facility, have been totally free, or would he have remained under some kind of conditional supervision? How did they, under the current system?
In the federal system?
Yeah, if Duran had been
I'm more familiar with the DC system at this point. We have USNGs at St. Elizabeth's who can, ultimately, we had one who was unconditionally released in 2011. That is a very long process, and it's really a step-down process. What you look at is, at each turn, the individual or the hospital could go and ask for further release, levels of privilege for the individual. There are several that we control within the hospital. When they get to the point where they're allowed in the community without supervision, that would be something that only the court can sign off on. And certainly we would notify the court, if there were any returns from that situation as well.
Under the scheme that Congress has written in Title 18, you have to certify at various points as to whether or not the individual who has been confined still poses a substantial risk to himself or to others or to property of others and so on. Are you comfortable doing that?
Conveniently, that's actually the job of the judge, not of the hospital. The
Well,
final
you have to
determination is that
certify.
of the judge. We make a recommendation. We are in service to the court in that situation. It's the judge who ultimately makes the decision whether the person is ready to be unconditionally released or not.
Well, okay, Professor Morse.
Well, you've raised a very good issue, which is how accurate are predictions of future dangerousness done psychiatrically or psychologically? And there's a distinction made between clinical prediction, where the clinician does it by the seat of his or her pants, using very, very structured instruments that have a real statistical base, and then semi-structure that blends the two. It turns out that the clinical predictions are the worst of all. They barely beat chance. With good validated instruments, you get better, but except in very, very, very clear cases, we're still not very good at predicting what's called low base rate behavior. That is, behavior that occurs very infrequently, such as homicide and things like that. So we have to make these predictions. We go into court and we make them, but Dr. Canavan is absolutely right. The judge finally has to decide, does this testimony meet my threshold for a significantly enough reduced risk that I'm willing to release this person?
I would also say at St. Elizabeth's, for instance, when we do risk assessment, it is for a particular level. And really what we're talking about when doing a risk assessment is in what set of circumstances is this individual likely to have problems? And what are the forces that could reinforce positive behavior given, the level of privilege they're asking for at this point. So you try to narrow the risk assessment to be in the circumstances that we think this individual will be most likely in, given this request for privilege, what are the things that would support pro-social behavior, and what are the factors that would indicate greater risk?
Do you know of any case where it's been certified that the person who had been confined no longer poses a substantial risk at all?
Well, certainly somebody who's been found, who's been unconditionally released, that is what the statement is making, is that...
Have you so certified an individual?
Well, in 2011, we supported a finding of unconditional release.
No, you have? Okay. Let's see if we have some questions. We have about 7 minutes remaining.
I have one question for the panel. How have, with respect to defendants who have been found not guilty by reason of insanity, how have the procedures changed over the last, I would say, 25 or 30 years in terms of making decisions about their treatment and making decisions about their release? Have those changed in the same ways that the laws with respect to finding people guilty or not guilty by reason of insanity changed?
Professor Morse?
Not appreciably. The only major, in 1983, in a case out of D.C., Jones against the United States, the Supreme Court was asked to decide whether a post-insanity acquittal commitment, which is more onerous than a straightforward civil commitment, was in fact constitutional. And the Supreme Court said you can distinguish for equal protection purposes people who've been acquitted by reason of insanity from people who are straightforwardly involuntarily committed just civilly. They also said that indefinite confinement is constitutional. And the reason it is because since the defendant has been acquitted, he doesn't deserve blame and punishment. The commitment has nothing to do with blame and punishment. It has to do with mental disorder and dangerousness. And so when does that end? When either dangerousness ends or mental disorder ends. Because it doesn't, there's no cap set by proportionality of what he deserves for the crime because he's been acquitted, excuse me. So that's the way it's been ever since until 1992 when Fuchs against the United States held that, in fact, if you are no longer mentally ill or are no longer dangerous, you have to be released. But there haven't been really major changes in this regard nationwide for actually decades. Yes, there's tinkering at the edges in various states, but California, for instance, now allows for conditional release. And if you spend a year in the community and keep your nose clean, then you're unconditionally released. for example.
Further questions? Further questions?
I had a question. I wondered if that's the way Dr. Canavan sees it. You see no change due to all those changes about handling defendants post finding of not guilty by reason of insanity by Congress in the 84 statute?
In the district, the hospital has always maintained a review board for at least, I believe, more than 27 years. There's been a review board, which is leadership of each discipline within the hospital, so that any petition that an individual would have would come before the review board first, before the hospital would form their opinion as to whether or not we would support that particular movement in court or not. That has not changed in terms of how we proceed with internal decision-making about whether to support someone's request for conditional release or unconditional release or other levels of privilege. I would say that it is very much jurisdictional, though. I think that, for instance, in Maryland, there are the likelihood that you would be indefinitely confined as a result of an NGI is dramatically less than it is in the District of Columbia.
Further questions? Yes, this lady.
In regards to the Hinckley case, I was just curious. I was wondering why it has to go back to a court. I understand that that's part of the law, but it was always my impression from listening to the press that even if the doctors were to say that Mr. Hinckley was able to be released, that the federal government and the Secret Service, for example, would oppose that. And I guess my real question is, if those assumptions are correct, why wouldn't a doctor who is seeing him professionally be enough to have it then proceed as opposed to going back to a judge? And is it because the bar is so high because of his particular incident or not? Thank you.
Professor Morse.
I think the short answer to that is this is one of those messy cases where the law and politics come together, and the frothy brew is not so pretty. This was the attempted assassination of a very popular president. Revulsion is still felt in some quarters, and because of that, I think just as a political matter, the bar has been set very, very high indeed. If this was nobody knew who he was, my prediction is Hinckley would have been out long ago.
Sir?
Does anyone know how Mr. Duran is doing now, what his mental status is like, and whether he was actually delusional or not?
I actually, I don't want to comment on his mental status, but I do receive notes from him generally once a year from Colorado. So he's doing, I think, as well as could be under the circumstances, let me put it that way, and of his long confinement. He is due to be, he got a 40-year sentence, so he has to serve like 34 years, I think, before he'll be released under the federal system. The government had asked for life, so he was actually somewhat glad that it was not a life sentence, let me put it that way.
Okay, a few closing words from our President, Steve Pollak.
Well, first of all, I'd like to congratulate all the participants for a wonderful program and give them a big hand. Thank you very much. I would like to thank the Federal Judicial Center and its team of experts for videotaping our program, which they do without charging us, and we're very grateful. And we think the public is grateful, both it's shown by them and shown by us on our website. Finally, I'd like to thank the committee members who really brought the program to life. Jeffrey Kleinberg, Jim Rocap, Carl Stern, Judge Pat Wald, and Judge James Robertson. And finally, I'd like to thank the society's Linda Farron, Doris Brown, and court staff members, many, but I'd name Ann Wilkins, John Kramer, and others for making the arrangements in the courthouse, which we had to have to present the program to you. Thanks for coming.